Katrina Knockleby, and I am the MLA for Great Slave and the Deputy Chair of this committee. We are currently conducting a public briefing on Bill 82, Legal Profession Act. Bill 82 repeals and replaces the current Legal Profession Act and purports to address developments in the legal profession as well as errors, inconsistencies, and improve overall clarity of the Act. As part of committee's review of Bill 82, we are holding a public hearing which is being live streamed on all Legislative Assembly channels. Thank you to those who are listening in and for those in attendance. I would like to remind all members and presenters to please pass all questions and comments through myself as the chair. And please wait to be recognized before speaking, as this will allow a smoother transition. I will now ask all members to introduce themselves for the record.
Caitlin Cleveland, MLA Cam Lake.
Rylan Johnson, MLA. Rylan Johnson, MLA Yellowknife North. Good afternoon, everyone.
Lisa Semler, MLA Nuvik Twin Lakes.
Thank you. I will now pass the meeting over to the Minister of Justice to introduce himself and to proceed with opening remarks and his presentation. Thank you.
Thank you, Madam Chair. I am pleased to be here today to discuss Bill 82, Legal Profession Act. Bill 82 proposes a repeal and replacement of the current Legal Profession Act, which was passed in 1976 and establishes the Law Society of the Northwest Territories as the body which regulates lawyers in the Northwest Territories. Today, I am joined by Brad Patzer, Assistant Deputy Minister, Attorney General with the Department of Justice, Christina Duffy in a very lawyerly looking office. She's the President of the Law Society of the Northwest Territories and the Director of Legislation Division with the Department of Justice, and of course my Ministerial Special Advisor, Ronna Sherigan. I would also like to acknowledge that other members of the Law Society are present with Ms. Duffy as well. And frankly, a little distracting, I must say. Madam Chair, I would also like to acknowledge members of the Law Society of the Northwest Territories, some of who are present and many who aren't. The department has worked in collaboration with the Law Society to bring forward these amendments and appreciates the time and effort contributed by Law Society membership, both with their initial review of the existing act and with reviewing and engagement on the draft of the bill. This helped to ensure we were able to bring forward a fulsome new act that will effectively regulate lawyers in the Northwest Territories. In 2018, a revision committee was established by the executive of the Law Society of the Northwest Territories to consult on and recommend changes to the act, which had not been extensively reviewed since it was first enacted. The act, as written, is prescriptive, with many issues governed by the act rather than the rules of the Law Society. Similar legislation in comparable jurisdictions is often less prescriptive, allowing for greater flexibility in the rules and policies of their law societies. The proposed new act would address contemporary developments in the legal profession in a manner similar to other Canadian jurisdictions. In addition to addressing errors, inconsistencies, and improving the overall clarity of the act, proposed changes to the act generally address the following areas: the purpose and administration of the society, membership and enrollment, the definition of the practice of law, discipline, the assurance fund, trust accounts and custodianship, and other relevant matters. Thank you, Madam Chair. This concludes my opening remarks, and we would be pleased to answer any questions from members. Thank you.
Thank you, Minister Simpson. I will now open the floor to member questions. Who would like to get started? MLA Johnson, go ahead.
Thank you, Madam Chair. I only have one line of questioning, as this was raised as a concern to me. In the previous Legal Profession Act, the practice of law is defined and it sets out the scope, and then it has this exemption under F that says if anything is done essentially without expectation of a fee or reward, direct or indirect, then it's not caught under the scope of practice of law. I note that's no longer in Bill 82. So essentially, there was an exemption for what the Legal Profession Act was regulating, as long as no one was charging any money or gaining any benefit from it. I guess it's just as a first question, someone can enlighten me to kind of the reasoning for this change. Was this a concern that we had? Thank you.
Thank you, MLA Johnson. Minister Simpson?
Thank you, Madam Chair. I will direct this through you, of course, to Mr. Patzer, and he may want to redirect to Ms. Duffy. Thank you, Madam Chair.
Thank you. Go ahead, Mr. Patzer.
Thank you, Madam Chair. Excuse me, I am suffering from a bit of a cold, so I apologize if I cough or into your ears. The practice of law was something that was wanting to be better defined by the members of the Law Society and the Law Society executive so that it could be, I guess, something that could be interpreted in terms of what a lawyer actually does on a day-to-day basis in terms of giving advice, drafting legal documents. I don't know offhand what the reason was for eliminating the reference to charging a fee with respect to that. I don't know if my colleague, Miss Christina Duffy, has any thoughts on that or not, Madam Chair.
Thank you, Mr. Patzer. Ms. Duffy?
Yeah, thank you, Madam Chair. There was a thought given to this, and ultimately, I think where we landed was that whether or not you're charging a fee, there's still a fundamental expectation about your qualifications and about your skills. And if we carve out practice based only on fees, then we don't have ability to ensure that legal services are being provided competently. So what we've done is create a broader bucket that deals with the practice of law, and then exemptions can be considered in that through rules or policy or sort of a variety of other mechanisms, but we want to make sure we cast that net wide so that we're appropriately regulating.
Thank you, Ms. Duffy. Mr. Johnson, do you have a follow-up?
Yeah. Yes, I don't really have a concern if we start bringing in people who are doing the practice of law without charging, who aren't lawyers. I imagine that doesn't even exist. I maybe some nonprofit people sometimes assist people and cross that line. You know, they show up to an eviction hearing or something to help a distressed person, and I assume they'd now be caught under that. But I guess my concern is the people I know who've used that section are retired lawyers who no longer want to pay the few $1,000s to the Law Society, and they, you know, often they're outside of the Yellowknife, and they're the only people that people go to for any sort of legal services. And I get that maybe the Law Society wants them to be active members, but they're just realistically not going to do that for the kind of community relationship they have. And I would like to find some sort of way that we don't prevent I can think of about who it applies to, from saying, okay, well, you just can't do anything anymore absent paying your licensing fee, when they've just kind of developed these, you know, beautiful pro bono kind of relationships. And I think we want to encourage that. And in the form of a question, I'm wondering if the Law Society is considered some sort of way to keep that non-fee based in there, where, you know, perhaps there is a status you waive your fees that are required if you are only doing pro bono legal services. Because I know there's some retired lawyers who would like to continue doing that, or lawyers who, you know, perhaps have other jobs and are doing that presently. Thank you, Madam Chair.
Thank you. Mr. Minister?
Thank you. I'd like to pass it to Ms. Duffy.
Thank you. Ms. Duffy?
Thank you, Madam Chair. We have considered that. I will say, I don't know that we're at the point where we know exactly what that would look like, but when you look at how we've classified registrants in the Act, we've tried to create this broad category that includes individuals providing limited legal services, which we think has the ability to have a lot of flexibility. A lot of work will have to be done on how those classifications would be decided and what might be done in relation to fees, et cetera. I'm not sure that they'd be none or whether it would be reduced, but I do think that exact kind of situation could be caught by something like that, and that'd be part of the work that we do as we revamp the rules.
Thank you, Ms. Duffy. Are there others with questions for the minister's staff? MLA Cleveland, please go ahead.
Thank you very much, Madam Chair. Madam Chair, and thank you to the minister and staff for joining us late this evening and for providing the presentation to committee tonight. Madam Chair, when I look at the scope of the bill compared to the recommendations that were put forward to the Law Society for this bill, there's a couple of things that didn't make it in, and I'm wondering if the minister or staff could potentially speak to some of those. And the first one is the executive rulemaking power to include the right to make rules supporting access to justice. And access to justice is something that we speak about quite often in the work that we do. And I'm wondering if the minister can speak to why this was left out of Bill 82 and where the department sees this responsibility laying. Thank you.
Thank you, MLA Cleveland. Minister Simpson?
I'd like to pass it to Ms. Duffy.
Thank you. Ms. Duffy, go ahead.
Yeah, thank you, Madam Chair. So yeah, obviously access to justice is very important from the perspective of the Law Society. And it's something that the Law Society has a piece of, but obviously not the whole scope of. There's a variety of institutions that are involved in that. When we looked at how to address access to justice in the bill, it became clear that there's not sort of like a finite thing that allows you to speak to that. It kind of underlies the whole system. So in our view, as we looked at it, it was about creating a competent and fulsome and responsive regulator, and that providing the foundation for access to justice more broadly. Again, back to my previous comment about offering limited legal services providers, that would be part of that. A variety of different ways that we might like look at the broader set there. There was discussion early on about the licensing of paraprofessionals, such as paralegals, as offering a broader set of options to people. Unfortunately, in this jurisdiction, that didn't really seem very practical. That's a very small group of people that would require a significant amount more regulation. And so it made more sense at this point to just create more flexibility with some of those things like limited legal service providers to sort of see how that unfolds at this point, because we don't see that request coming from the public and we haven't really felt the need to go that way yet at this point. I think the other thing that we're alive to in all of this is that when we look at our role in access to justice, we just have to stay inside the mandate of the Law Society, which is to regulate lawyers exclusively. And so that's sort of our piece in it. And so when we look at sort of ongoing continuing legal education and some of those other pieces, that's where we sort of think we fill our gap in, and then we work with other bodies to do more broad things.
Thank you, Ms. Duffy. MLA Cleveland, do you have a follow-up?
Yes, thank you very much, Madam Chair. And in that same vein around access to justice, the other one that was left out that has actually come up multiple times in the course of this assembly is the piece around the ability to make rules to establish and maintain libraries. And so I'm wondering why this piece was specifically left out, given that it would also essentially be not only a tool for access to justice, but a tool for the membership of the Law Society as well. Thank you.
Thank you, MLA Cleveland. Minister Simpson?
Thank you. I'd like to go to Ms. Duffy.
Thank you, Ms. Duffy.
Thank you, Madam Chair. Yes, this was a big issue for members too when the former law library closed. That met with a lot of concern amongst the membership. Ultimately, where we landed on this is that two things, I think. One is being cognizant of our mandate, which is the regulation of the profession, and the other is practical implications in terms of how we allocate resources that we do have for those sorts of initiatives. So there's two, maybe three sort of main areas that we're using to increase access to legal materials. One is that we do the Legal Profession Act, the new Legal Profession Act will continue the Law Foundation, which does have an express mandate for law libraries and access to legal services. And the Law Society both appoints members to that board with a view to access to justice and also provides funding through interest on trust accounts and sometimes through additional funds. We also do, in fact, provide quite a bit in way of resourcing, both through agreements with Justice and through the Federation of Law Societies. A few years ago, the Federation of Law Societies brought together all of the law societies in Canada to purchase CanLII, which is the online legal databasing system. And from our perspective, the law library here was pretty limited in the amount of resources that it offered, and the amount of money that we can put towards CanLII, which is much more fulsome, was a better way for us to sort of meet that objective. So we definitely take the question of access to legal resources very seriously, but we thought that maybe the physical law library wasn't the best way to go about that.
Thank you for that. Are there other questions? Yeah, go ahead, MLA Johnson.
I lied. I had one other line of questioning. I know there's a bit of a debate in Canada right now to regulate paralegals. I know Ontario, under their act, creates paralegals and sets out what they can do. I think in the NWT, we have people we call with job titles who are paralegals under the supervision of lawyers, and then we have quite a few in the government who are just, we call them paralegals, or I'm not really sure they supervise the lawyers, but I'm wondering why the decision, or whether there are any plans to create this kind of regulation of who is a paralegal and what they're allowed to do. Thank you.
Thank you. Minister Simpson?
Thank you. Back to Ms. Duffy, please.
Thank you. Ms. Duffy, please go ahead.
Thank you, Madam Chair. Yeah, there definitely was discussion about this and quite a bit of interest. We've seen, as Mr. Johnson said, like a lot of interest in this, primarily in the larger jurisdictions that have really the resources and the volume of people doing that work. For us, it didn't seem practical given the volume of people. And so what the backstop is to that in here is a very carefully framed definition of what is the practice of law, so that we can draw those lines appropriately around the people that we feel we need to regulate. At this point, it doesn't seem as though there is a need for more than that at this point, but we have tried to frame those things about limited legal service providers in such a way that we could take some steps forward in our rules, and if the appetite grows in the future to do something more fulsome than that, then we would be looking at further amendments at that point. But for now, we think we have the authorities that we need to do some base level regulation.
Thank you. Next on my list, I have MLA Cleveland.
Thank you very much, Madam Chair. And I just wanted to ask one last question that is in a similar vein to what I had asked during our briefing this evening, or our public hearing this evening on the Nursing Profession Act. And it's in regards to training. One of the things that the GNWT does right now for staff is it does have Living Better Together training for staff that is speaks to the history of the Northwest Territories, and one of kind of a growing field of training that you're seeing down in Southern Canada is trauma-informed cultural safety training, but specific to the justice system. And I'm wondering if there was conversation from the GNWT or the Law Society about what type of training in that regard is expected of the membership of lawyers practicing in the Northwest Territories, and whether or not there was conversation about making that training mandatory for people practicing within the justice system in the Northwest Territories. Thank you.
Thank you very much. Minister Simpson?
Thank you. So the act that is in force right now that we are attempting to replace was written before most people on this call were born. And so references to specific types of training need to be, we need flexibility in the act. And so that is what the goal was. So Ms. Duffy can elaborate on this a bit. Thank you, Madam Chair.
Thank you. Ms. Duffy, go ahead.
Thank you, Madam Chair. The minister is exactly right. That's why we didn't put anything more specific in the legislation, but I will say that we have already quite fulsome rules about ongoing competency training for lawyers. And in fact, we currently have a mandatory cultural competency program. Living Well Together is one of two options that members are entitled to choose from. There's that, or one that's offered by the Canadian Bar Association that's a little less northern focused, but a bit more legal in its content. So they had the opportunity to choose one of those. It was mandatory for all members, and we anticipate that continuing, as well as continuing to reassess on a fairly regular basis what we think is required. We have, in fact, offered some CPD in the past couple of years on trauma-informed lawyering. That hasn't been mandatory, but that's definitely something that we'll be looking at, both as we develop the rules the first time, but also on a very regular basis, is what is required for continuing professional development to maintain those standards of competency.
Thank you. Emily Cleveland, do you have a follow-up?
Yeah, thank you for that. And I guess not so much a follow-up, but just, if not a follow-up question, but just a comment is, in speaking to different people who are Indigenous involved in professions around kind of the justice field, understanding our history is one thing, but definitely the conversation is growing as far as more that trauma-informed practice. And so I'm really happy to hear from Ms. Duffy that is a direction that they're looking at going, and I look forward to learning more about that in the future. Thank you.
Thank you, Ms. Cleveland. I'll take that as a comment. Now, it is my understanding that the Law Society is going to present to us as well. Unless if there's any further questions for the minister, we could move on to that presentation. Seeing none, is that, go ahead, Minister Simpson. Did you?
Oh, I was just going to say goodbye.
Oh, okay. Yeah, I didn't know if you were going to stick around. So thank you so much to you and your staff for being here and being available to answer questions for us. Thank you.
Thank you all. Take care.
Okay. So with that, I will pass the floor back over to those in the Law Society room. If you could introduce yourselves and let us know and proceed with your presentation. Thank you.
Thank you, Madam Chair. My name is Chris Buchanan. I'm the Treasurer of the Law Society, and I'm joined here with Ms. Duffy, who you know quite well now. She's the President of the Society, and I also have Keelan Simpson, who is our Secretary. And I'm not sure if he's joined the other line, but Matthew Yap is our member at large. So we're here today. Oh, yes, he's here.
Yes, hi.
I wanted to make some comments about the bill. Ms. Duffy has already addressed a number of areas that we were going to comment on. We were going to respond to Emily Cleveland's letter, which asked for some submissions on 4 points. 3 of those points have been covered by Ms. Duffy, which is great. So what I'll do is I'll just address a bit of background of the Act and then address the final points, which we haven't spoken to yet. So I just start off by saying that we're very pleased to be here today, and want to thank the committee for inviting us to make submissions about Bill 82. As the minister mentioned, this is an old act, so it's ripe for review. It's been a long road to get to this point of reviewing Bill 82. In August 2018, the Law Society struck a committee to review the bill or the act, and then in September 2019, there was a discussion paper issued, which provided a comprehensive analysis of the act, and I'm sure the committee is familiar with that discussion paper. And then there was a consultation period with our members in February 2020 on that discussion paper, and we received some good feedback. And then, of course, the Department of Justice drafted the bill, and then the Law Society executive was consulted on that earlier draft of the bill earlier this year. And so just generally, the Law Society is supportive of the passage of Bill 82. We think it's necessary, and generally we are supportive of all the provisions there. So just regarding the 4 points raised by Emily Cleveland, the last one that wasn't addressed earlier today is the discipline process. So the point there was that the committee wanted to hear about the discipline process. There's an acknowledgement that there's several clauses in the bill that address and improve the process and expand options. And so this is a significant change in the Act. It is a very hot topic for us, discipline. As a self-regulated profession, this is a key component of what we do. The legal profession is one of the last remaining self-regulated professions. So this is something that we take very seriously as a profession. And so what you see here, I'll just address a couple of ways that the Act addresses discipline. So the first one is there's a distinction drawn now between incompetent conduct and sanctionable conduct. And so it kind of creates a bit of a tier system in terms of how serious conduct is, which is a change. And so now you have incompetent conduct, which is something that can be sanctioned by the chair of the complaint investigation committee. So that would be the discipline committee or a tribunal. Whereas if you have sanctionable conduct, which is more serious, that's something that would be sanctioned by a tribunal or a court. So there's a distinction there. And so we felt that was a good change because it provides a bit more options for the Law Society to deal with discipline. And this is all something that would be assessed through an investigation. So that's all set out in the Act. The other change we see and we like is the various alternative options now for dealing with discipline. So there's different approaches, including alternative dispute resolution, referral to wellness programs, or advice to the registrant. As you can guess, the practice of law is quite stressful and complex, and that can lead to mental health challenges, and we do see that in the profession. So having the options of allowing members who are struggling perhaps with their practice, not to be necessarily sanctioned, but to receive support like wellness or advice from a senior member, it's good to see. So we are supportive of Bill 82's approach to discipline. That was really everything else. The ongoing education, access to justice, Ms. Duffy's already addressed. So I would just leave it at that then and say that, again, we're supportive of the bill, and we're happy to answer any questions you may have. Thank you, Madam Chair.
Thank you, Mr. Buchanan. Members, are there any questions for the Law Society that Ms. Duffy has not already answered for us this evening? Go ahead, Ms. Cleveland.
Thank you so much, Madam Chair. And I'm wondering if Mr. Buchanan can answer, or someone from the Law Society, sorry, can answer just in regards to the discipline process. One of the things that was brought to my attention is that the discipline process has mechanisms for disciplining people involved in, their membership, so lawyers, but that the discipline process is brought forward most of the time by a resident who just wants to have their legal issue sorted. And so, sometimes it might be somebody going through a divorce who's not hearing back from their lawyer, and they're calling, and so they kind of go through the discipline process in order just to get a call back. But there isn't a mechanism within the discipline process to ensure that that person gets a call back, gets their case sorted, and deals with what their issue is. It really focuses on the membership. And so I'm wondering if maybe the Law Society can speak to that, and whether there is within that discipline process a remedy for the actual resident who needs legal services. Thank you.
Thank you, Ms. Cleveland. Mr. Buchanan?
Thank you, Madam Chair. So right now, the way it works, and I think this is how it would work going forward with the Act, is that there's a bit of an administrative component to the way that the Law Society sort of filters or vets complaints. So the way it works now is that if someone has an issue with a lawyer, they would call the executive director and explain their issue. And there's a bit of a sort of informal dealing with issues that don't necessarily fall under the category of misconduct. So if someone says, the lawyer's not calling me back, that's where the Law Society would pick up the phone with the lawyer and say, hey, this person is looking for a callback. You should deal with them and call them back. So there is some vetting that happens there. And so that would be more administrative. But, if it comes to a point where you need to have the investigation committee involved, then there is a process now in this act that lets the committee review that conduct. There is the issue, of course, is that there's only so much we can do as a Law Society, and there's only certain conduct that we can actually review. So what we find is that some people call and it's not something the Law Society actually can deal with necessarily. So that's where the executive director would step in and explain, this is how it works. And yes, maybe that is an issue and we should refer it to discipline. But that's not something that's necessarily in the Act. It's just something that ends up happening at the administrative level. I don't know if you have any other.
Yeah, I'll just add that that exact question was sort of part of the impetus for this, because as the legislation reads right now, it actually appears that once you file the complaint, we have no choice but to put you through the discipline process, even though quite often that is actually not what people are looking for. So that first off-ramp right at the very beginning is now authorized by the legislation in a respect. And so it gives us a bit more discretion to be able to work with people, because it's true. A lot of them really I don't think they ultimately care if their lawyer gets sanctioned. They want to just see a resolution. And so now we feel like we have some ability to work with them a little bit more broadly.
Thank you. Appreciate that. Emily Cleveland, did you have a follow-up?
Thank you very much, Madam Chair. And I'm going to admit I'm not super familiar, and so I'm hoping that somebody from the Law Society can answer this question for me then. Is there room then to add a requirement to somehow provide solution or provide at least follow-up to the complainant in that process, so that they know either what's happened or what their kind of next remedy is within that complaint process? of how to basically have that access to justice to be able to move their issue forward within the justice system. Thank you.
Thank you, MLA Cleveland. Mr. Buchanan?
I'm going to defer to Ms. Duffy on this one.
Go ahead, Ms.
So
Duffy.
sorry about that. I think we want to distinguish a little bit between what is the discipline process or the conduct deserving of sanction and those other remedies. I think what we're really trying to do here is not conflate them in any way, because that is what often leads to disappointment for people, is thinking that they're going to get that remedy they need out of here. So I don't want to say there's room inside of that process to do that, but I think that's something that the Law Society might be able to do better, although I'm not sure if the legislation really needs to reflect that, is make it known that, you can call and ask those questions. We are a small law society, a small group of people. Those calls get made quite often. And so, maybe it is looking at our website and some of those things to see if there's ways that we can make people understand what is available to them. Because I think quite often if we rely on that discipline route as being that mechanism, then people are inevitably disappointed because it doesn't lead down that road.
Thank you. Does anyone have any further questions for the Law Society? I am not seeing any hands come up, so I would like to thank you very much for joining us this evening. You're welcome to stay on and listen, as we have one more presenter here this evening that wants to share a personal experience himself. So I'd like to invite now Mr. Flewelling, I hope I've said that right, who is joining us virtually to speak to the bill. I just checking, we'll make sure that we're connected. Mr. Flewelling, can you hear us? He was there earlier. Mr. Flewelling, we're just trying to get you online here. I know that you're showing as being open and not muted. I know that Mr. Flewelling is actually back on the East Coast somewhere, so I'm just wondering if perhaps we have lost his connection, or perhaps he has taken a call or something. Okay, we won't keep everybody here on the line further. We will invite Mr. Flewelling to come back another day and chat with us as a committee. Was there anything, sorry, I should have asked, from the Law Society, from Mr. Buchanan, Ms. Duffy, Mr. Yap, Ms. Koppel, if there's anything that you would like to say in closing to the committee? Mr. Patzer, you're still here?
No, thank you. Thank you, Madam Chair.
Okay.
Madam Chairman, I don't know.
Yeah. Mr. Flewelling, is that you?
That's me.
All right, you have the floor. You got us in time. We were just about to give up, so go right ahead.
I'm a senior and I'm not a techie person. Madam Chairman, MLAs, committee members, Law Society people, if they stayed around, and anybody else that I have missed. I have filed a complaint and sent multiple documents, and I basically just want to go over a couple things that I missed when I sent my last email that had like 4 things that I would like to see possibly change in the law. So the first section is about getting an appeal process. And that would give, and as it was stated before, it would give the general public at least a chance to be able to prove certain things without having to get a $25,000 fee for judicial review. In my particular case, if I was able to appeal it and went to a hearing, I could prove a lot of different things. Like there was a phone call between myself and a lawyer. The investigator didn't ask me, did somebody else hear it? Well, that was important for people to know that there was somebody else to hear it. And And I have a real concern because the lawyer involved sent, as part of his reply to the complaint, a correspondence between him and his client. I know there's confidentiality, this and that, and whatever, but to me, it felt like it was, how can I put it this way? It was unethical for him to try to throw me under the bus without me having a chance to see what this was. But thank heavens the investigator messed up and sent that first before taking things out. So I think by having and that to me is, I guess it's Rule 5.1-5, 7.211, and Section 22 of the Act, where they're basically saying that a lawyer must be courteous and civil and act in good faith when they're dealing with people. To me, this was just very, very unethical. Okay, so that to me would be grounds for me if I could go to an appeal board or however they could put it up so that at least all the facts would have been presented, not all of them. So that's what I'm really pushing for from a public's point of view, is something that they can appeal to. And, maybe I'd get it. Maybe I get a hearing, maybe I lose. Okay, that's fine. But right now, it seems to me that because he did that, my constitutional right to a fair hearing and to see what all the evidence was from him was violated. The next thing I want to talk about is, and I don't know if the Law Society hears not, that I was basically told, like, if there's 3 people going over the complaint, I'm not allowed to know who they are. Well, to me, that it causes a problem because there could be conflict of interest on both sides between myself and this lawyer. So I think maybe that's something that, unless the Law Society has something that they do to prevent that, I don't know. That's just sort of a comment more than anything else. Now, the third thing I want to talk about is the investigator. Nice guy, and long, good conversations. And like I said before, he sent me the response with something I shouldn't have seen. Okay, so let me see. Again, there was a statement by this lawyer that it was a rather straight, threatening email. Well, the investigator never asked me to produce it, and this lawyer never sent it. He sent another email saying what he was going to do because I was calling his office looking for my money. Okay, so that's another thing. The investigator did not contact a judge who had said something. This is all in the information. And the man who was changing the law. Apparently, the investigator cannot do this. The investigator his job should be to get all the evidence, go out between the two sides, talk to people, get all the evidence, and present it and say, okay, he broke the law or he didn't break the law. He didn't break the law. If he breaks the law, I believe the ethics committee, the discipline committee would take over from there, or even another committee could deal with punishment. And also in Section 22, it's something about that on misconduct and et cetera, such to harmful to the best interest of the public. So him doing that to me, the public, is not to the best interest. Because what could happen is that could get out into the public, and all of a sudden, boom, you know, it's an unethical thing as far as I'm concerned. My last little thing I want to talk about is file transfer between lawyers. And basically, I think I've explained everything in there. And in my case, I had 3 lawyers that I had to fight tooth and nail. I had to call people. I had to email people. I had to try and find out, you know, what the heck was going on in this estate once I was done with it. And this lawyer, I meant to say this earlier, actually, because I had mentioned the judge in our first hearing. After the judge gave us our instructions, the lawyer started arguing with the judge, and the judge's comment was, "You better go back to school because you didn't know his state laws." Well, if the judge says he doesn't know his state's law, how come he's allowed to practice? So I think that's all I have to say. Most of it's there, but I really want to emphasize getting something in there for the public that they can go to and appeal with cause. And I believe that's all I have to say. If there's any questions, I'm certainly here. My team won the hockey game, so I've got lots of time to talk now. And thank you very much for the opportunity to speak and elaborate on all this stuff that I had sent in. You guys must be crazy, think I'm crazy because I sent a whole lot in. Thank you.
Thank you, Mr. Flewellen. You'd be surprised at the things that we read and hear as MLAs. I do appreciate you taking the time, particularly because I know it's very late in the evening for you where you are. And I think you have some supporters as well around that public appeal piece. So I do appreciate that. Are there any questions for Mr. Flewellen from committee members? No, we've had a long time here. We do have your submission, Mr. Flewellen, so we'll definitely take a look through that. And if there are further questions that come to mind after, we'll follow up with you. Is there any last words?
Yes, I've been dealing with.
Go ahead.
Sorry. I've been dealing with a lady, Amy, I believe, is one of the people that I've been dealing with. So she has my email and contact information too. So thank you.
Yes, Amy is one of our amazing staffers. She's actually sitting next to me. You just can't see her right now. So we will definitely be in touch with you to follow up on that. So with that being said, I know it is a little bit of a later evening, so I want to thank everybody for joining us virtually this evening, as well as to the Minister, staff, and the Law Society, Mr. Flewelling, for joining us. It can only help us to make our work better when we are informed by people that are subject matter experts, and then also people in the public who have experienced working with professionals. It does help us to stay very informed. So thank you so much, and that concludes the public portion of our meeting, and we will cease our live broadcast. Thank you all.
Thank you. Thank you.